Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource for trial and appellate attorneys. Both Jeff and I are appellate specialists, but we try to split our practices about evenly between trial and appellate courts. And in each episode, we try to bring some perspectives to our audience of trial and appellate attorneys that they can use in their practice.
And a quick announcement. This podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse CaseText. Listeners of the podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
And today we're privileged to bring Justice David Thompson to the podcast. Justice Thompson capped a 24-year career on the bench last year when he retired from the California Court of Appeal for the 4th Appellate District, Division 3. By that time, Justice Thompson had authored more than 700 opinions and concurred in thousands more. Justice Thompson is now a neutral with jams. Before being elevated to the appellate bench, Justice Thompson was an Orange County Superior Court judge for 15 years and served as the assistant presiding judge of that court in 2011 and 12. And prior to taking the bench, Justice Thompson was in private practice for 14 years with two large civil firms. And as a civil litigation attorney, he handled general business, construction defect, landlord-tenant, product liability, and real property related cases for companies and individuals. Justice Thompson's a graduate of UCLA, where he was Order of the Coif and took his BS in Business Administration Finance from Georgetown University, summa cum laude. Welcome to the podcast, Justice Thompson. Thank you for being here.
Thank you, Tim.
Now, you started your career working for judges. You worked as a staff attorney for Justice Edward Wallin, and that presaged your elevation in later years to the appellate bench. Did you know at that early stage in your career that that's where you wanted to end up, on the bench?
Not at all. That's mostly an accident of history and a certain amount of luck, actually. When I was a law student at UCLA, I got to know then Judge Wallin, later Justice Wallin, through some friends, and he offered me an externship with him while he was still a Superior Court judge. And the word was out that he was going to be appointed to the Court of Appeal, and we sort of contemplated that that would happen during the semester that I was with him, which would have been the fall of 1982. But for a variety of reasons, that didn't happen until very late in the semester. So he then asked me to come back and be one of his first research attorneys at the Court of Appeal. So that was, in fact, my first legal job after I took the bar exam, and it's where I finished my career as a judge, 4th District, Division 3.
And that's interesting. That was being a research attorney at the Court of Appeal was your first job out of law school. And I would have thought that, one of the things that is very difficult about becoming an appellate attorney is that you have to know a heck of a lot about civil procedure. You have to know a lot about how things work in the trial court. Did you find that to be a steep learning curve to kind of hit the books and learn about civil procedure in trial courts?
It was, but Justice Wallin was a very good mentor, and he and I had established a relationship, a close working relationship. And so I was able to bridge that. The bigger challenge for me was my experience and training that far had focused on civil stuff. And of course, he was handling criminal cases as well. And occasionally I was called upon to assist him with a criminal case. And just a funny story, I wrote one criminal opinion for him, and we filed it. And the next day we got a petition for rehearing, which cited a recent U.S. Supreme Court opinion that was directly on point and went the other way. And Justice Wallin suggested that perhaps we should grant the petition for rehearing in that case.
In my experience, that's a very rare thing. Petitions for rehearing are not often granted.
This is my experience as well.
Yeah.
When I was outside my area of expertise, it didn't occur to me that perhaps I should look for recent U.S. Supreme Court precedent.
It doesn't seem to often come into play in our state system, but when it does, I guess it has impact in a big way, as you saw in that experience. So when you go ahead.
Oh no, I was going to say true enough. Absolutely.
Yeah. Now, when you left the Court of Appeal to go into private practice, What were did you find that experience valuable in private practice?
Absolutely, and it actually the experience with the Fourth District as a staff attorney was an afterthought. I had already been a summer associate at Rutan and Tucker and had been offered a permanent associate position to commence when I took the bar, but because Wallen wanted me at the Court of Appeal, he called the managing partner and they negotiated, and it was agreed that I would go to the court for 6 months before I commenced my career at Rutan. But truthfully, the experience that was more relevant to my early practice at Rutan was my days as an extern on the Superior Court with then Judge Wallen. You learn a lot more about the nuts and bolts of litigation practice and just the day-to-day life of a young associate, writing and arguing motions and how to talk to the clerk in the courtroom and practical things like that.
Now, during your time in civil practice, can you recall a litigation mistake that either you made or that you saw another colleague or another attorney make that you'll never forget? And since you've won all these high IQ awards, it'd be great if you could share an experience of a mistake that you made.
I told you one just a minute ago,
Yeah.
not researching the relevant law, but I have a couple of war stories from the trenches as a trial judge that might speak to the point you're raising. The first thing I would say is there is no case and no client that's worth compromising your integrity, and that's the headline that comes out of this story. I presided over an important, substantial civil trial, and the plaintiff himself testified in a materially false way. And it came out during the plaintiff's case in chief that the false testimony was given, and it wasn't revealed until he was recalled as a defense witness in the defense case, and then cross-examined and confronted with irrefutable evidence that he had lied to the jury. And the witness, the client on the witness stand, pointed at his lawyer and said, "He knew all about it." To which the lawyer responded in front of the jury, "I never told you to lie to this jury." You can imagine that might have had an impact on the outcome of that trial. So that's a story where maybe in discussing the matter, they thought they were skirting the subordination of perjury because of the way the questions were asked, but it blew up in their face in a spectacular way, and I will never ever forget that one.
Yeah.
Two more quick things, and these are almost like pet peeves. One is inexperienced plaintiff's counsel would occasionally call the defendant or a principal defense witness as their first witness in the plaintiff's case in chief under 776 or whatever that evidence code section is, thinking, well, I'm going to surprise them, right? And so what usually happened was they asked a few cross-examination type questions, but then defense counsel was permitted to examine that witness and essentially put on the entire defense case in the middle of the plaintiff's case in chief, which I just thought that was strategically an error. Rarely did anybody gain any real advantage out of that strategy.
I have seen that strategy implemented as well, and it does seem a dicey gambit.
Unless the defendant is spectacularly bad and not credible,
right,
and will make a bad impression, it's not really worth it.
Right, but if the game plan is to surprise your opponent, you might be the one that end up getting surprised. The third thing I would say, just as a general rule, was I saw many lawyers, maybe this falls under the heading of myself included too, paid inadequate attention to jury instructions and verdict forms before the trial started. Many times, they're supposed to be turned into the trial judge before you call your first witness. Many times we get to the end of the plaintiff's case in chief and I would ask, what's going on with the jury instructions and verdict forms, and the partner trying the case would say, my associate is working on them, and I would say to myself, this is fascinating. How do you know what it is that you're trying to prove?
Now, Justice Thompson, your former colleague, Justice William Bedsworth, upon your announcement of your retirement, is quoted as saying of you that, quote, Justice Thompson has a rare combination of hard-headed, straight-ahead approach to the law and a big heart that never lets him lose sight of his impact on his decisions will have on real people, end quote. Now, I want to skip over all the rest of the nuance and everything and just zoom in on the one word that he said describing you, hard-headed. Where did he come up with that? Why did he call you hard-headed?
I wouldn't presume to speak for Justice Bedsworth. He's a master craftsman with words, but I assume that what he's talking about is my propensity to just say what's really on my mind and to be fairly direct with people in whatever way it seems appropriate.
And was that your demeanor during panel conferences and talking about the opinions? Just launch off with your take on the case?
No, I don't think so much, but not because it's not my basic nature, but more because the number of cases where we actually sat face to face and had as a panel a discussion about a case is relatively small. Maybe we'll get into that in some of your other questions later. Most cases, there's a summary circulated before oral argument that the panel members have reviewed. Most cases, there's no discussion amongst the panel before we take the bench for oral argument. And in many cases, the sum total of the panel discussion is, as we're walking off of the bench and back into the robing room, is everybody okay with the summary? And unless there's some dissent, that might be the sum total of it. So we're largely dealing with communicating in writing. But I think Bedsworth's remark is more directed to how I might conduct questioning in the courtroom.
I see.
Yeah, and maybe you just answered the next question. In reviewing your the thousands of appellate opinions you participated in over your career on the bench, it seems like we only found 2 times when you wrote a dissent. What do you think accounts for such a small percentage of dissents, either by you or by this particular division?
Well, I don't want to impugn your research skills, but I think if you look a little deeper, you'll find more like 24 dissents.
Okay.
That was my research faux pas then.
Maybe that was published.
So there are more than 2.
Maybe it was 2 published.
2 published dissents. That might be true. I'm a little surprised. I would think it would be more like somewhere between 5 and 8 published dissents. But it's an important question in the sense that different justices have different opinions or philosophies about the purpose and utility of dissents. A significant number of justices think it's important for the court to speak with one voice, and it brings a certain imprimatur of certainty to the question when the court does that. I, on the other hand, think that if reasonable minds can differ on a question, that it's my job as a justice, that's why there are 3 of us, it's my job to articulate that viewpoint, separate viewpoint, even if it ends up being a minority viewpoint. I think that's how the common law develops.
Interesting. And would you ever dissent as a signal to the parties that, hey, you should go up higher and see if the Supremes might be interested in this decision?
Yes, I think that might be part of the thinking, but I can tell you that the number of cases where the Supreme Court took up a case where I had dissented and then actually spoke on the question is relatively small. In fact, I can't think of a single example where that actually happened.
Huh.
I want to ask you a question. Speaking on the topic of dissent, something that's always flummoxed me when I see a split a split decision on an appeal from a judgment after a summary judgment grant, when the majority finds that no reasonable juror could have found a triable issue of fact, and then there's a dissent with one of their colleagues says, I would have found a triable issue of fact. Is that am I wrong in being flummoxed by that? If a reasonable appellate justice could find that there was a triable issue of fact, then isn't there something wrong there in holding that there's not?
I think the answer to your question is yes. And if you look, there's a case that I dissented in under just those circumstances, and I went a little farther and accused the majority in that case of purporting to decide the factual question, which is not, of course, the role of the Court of Appeal are not appropriate under that circumstance. I said what was really going on was that they were weighing the evidence. I think that's Huerta, Huerta versus City of Santa Ana. It had to do with a personal injury case. The victims were run over in a crosswalk on a dark Halloween night in Santa Ana, and it had to do with whether there was a dangerous condition in the intersection and perhaps some shadow cast by a tree under a street light and so on.
Yeah, we will post a link to that case in the show notes if our listeners are interested in reading the Huerta case. Now, let's talk about looking back on some of your other times on the bench. And now that you're moved into private practice at JAMS as a neutral, what surprised you when you moved from first the trial court bench to the Court of Appeal bench? Were there what was surprising in that transition?
One of the things that surprised me was the relatively small percentage of cases that had truly arguable issues. I thought, going to the Court of Appeal, I'm going to be involved in all of this lofty intellectual discourse, lots of vigorous discussion, and it turns out that something like 10% of the cases or less have an issue that's really arguable and worthy of discussion. Part of that is because all the fact finding has been done below, and of course the Court of Appeal doesn't do any fact finding. Part of it is that by the time the dust settles, the legal issues are fairly well defined. And so I just found it quite surprising that we didn't have more cases where reasonable minds really could significantly differ, and that we would have these debates back and forth. Another thing that surprised me was, go ahead. You want to ask?
I wonder, is that part of that driven by criminal cases and free appointed counsel?
Absolutely.
Yeah.
Absolutely. I would say there's a higher percentage of civil cases. And if you look at the reversal statistics in whole or in part, that makes the point that you just made. Defendant has a right to appeal in a criminal case at the public's expense. He's got no incentive not to appeal, and so he'll file an appeal regardless of whether it's meritorious. Civil cases, if you have presumably rational clients and competent lawyers, an appeal should not get filed unless there's a real question that has legs for appeal.
Right. Right. Interesting.
Yeah.
What is something about what's something about private judging? Now that you're a neutral with JAMS, what's something about private judging that you especially enjoy, or something that surprised you about being a neutral?
What surprised me is the extent to which ADR has grown. After 10 years in the Court of Appeal, I wasn't aware of what ADR efforts were going on around those cases by and large. As a trial judge, and I knew as a trial judge in 2001 through 2008, let's say, I knew cases were going to ADR because I was either ordering arbitration or mediation, or the parties were going to ADR on their own, and I was getting a report, case had settled or whatever. But the practice has really exploded So the number of cases where ADR is being, in some capacity, is being used surprised me. The other thing that surprised me is the preference for virtual ADR. I came on at the tail end of the pandemic here. During the pandemic, everything went online, and it's now clear that the lawyers and the clients prefer virtual over in person. That was a surprise to me.
Yeah.
Well, on the subject of virtual appearances, in terms of oral argument on the bench, do you think there's some value in retaining video appearances after life returns to normal after COVID?
I think it's going to be a fact of life. It may even be dictated by the legislature. A friend of mine who is a state senator is interested in pushing that and preserving the right to appear for efficiency and cost-saving purposes, instead of having the lawyers need to travel and so on. I think virtual is here to stay in some form or fashion.
I will say, from my perspective, I miss going into court. I was COVID cautious. I hid away for 2 years during the pandemic, but I miss going to court and seeing the body language. And we had some glitches in terms of the cameras on this podcast before we started, and that fear of technical glitches never leaves me for a video argument.
Understood.
Yeah.
I think there's something lost at the margins with virtual communication. There's some intangible that you get when you're actually sitting in the same space with another human being that doesn't come across on the camera. And I prefer in-person proceedings myself.
And are your comments about Zoom and virtual proceedings being the new normal, is that were you talking about the Court of Appeal, or are you also talking about trial courts?
I think that's going to be in the trial courts as well. There is now, or soon will be, some legislation pending in the state of California, if I'm not mistaken, that's going to assure that in non-evidentiary taking types of hearings, that the parties have a statutory right to make a virtual appearance. When you're calling and questioning witnesses, it's a whole different matter.
Right. Yeah, I just note that was it last month? I think it was July, actually, late July. There was a published opinion out of the First District Court of Appeal, Reese versus Superior Court. It was a writ petition granted after a trial judge refused to denied a motion to transfer venue from San Francisco, where this case against Uber was filed, because Uber's headquarters is in San Francisco, to transfer venue down to San Diego, where all the actions occurred and where all the witnesses were. And the trial judge had said, "Look, we can do everything virtually. No point in transferring venue." And the Court of Appeal said, "Nah, not so fast." The Section 397, the venue transfer statute, I think I've got that right, is says that you have to make a individualized determination about whether the proceedings are just as good via Zoom. And until the legislature changes that, and that's probably what you're alluding to, Justice Thompson, that there may be some legislation on the horizon, because the temporary statute implementing or allowing for virtual proceedings is set to sunset next year, July 1st, 2023. So I think that's a space to watch for the legislature to act, because there's been a lot of talk about whether this is the new normal, and we've all discovered whether we think that in-person can be completely supplanted. I think everyone agrees that case management conferences and things of that nature, routine law and motion, discovery motions, probably can be just conducted via Zoom. We don't need to schlep across town for a lot of these routine things.
Absolutely true. And I'm finding in the mediation context, where you have carriers or principals that are in New York or wherever, they have a very strong preference, and you get better participation if you can allow them to participate virtually.
Yeah. Now, your former court, the 4th District Division 3, has had 3 other justices retire somewhat recently. And also, of course, we all know that the Chief Justice of the Supreme Court is retiring. When do appellate justices tend to begin contemplating retirement? I take it's not the same thing as a federal appeals judge, where the Supreme Court, for example, they never retire,
Right.
except in very rare circumstances. It's a big surprise when that happens. It's not as big a surprise when state appellate court justices retire, and as we saw, there were 4 from one court retired all in the space of, I think, about 24 months. I wonder how that came to pass. And Justice Bedsworth, of course, has announced his retirement unsuccessfully, I think 3 or 4 times in the last few years.
Yes, and I'll believe that one when I see it. There have actually been 4 retirements from 4th District Division 3. It was Icola, Aronson, myself, and then Justice Feibel. I expect there's going to be some more retirements from that court in the next 12 to 24 months as well. I think the retirement is mostly a function of age and health and post-retirement plans. And to some extent, it's a function of which judicial retirement system you're in. Judges appointed prior to 94 are in JRS 1, after 94, JRS 2, and the retirement parameters are somewhat different. And there was a bill signed by the governor yesterday that amends JRS 2 in some material respects, so that'll have an impact as well. But basically, what I would say is, unless a judge is intending to have another career post their career on the bench, most are staying as long as their health and their interest level permits. And so you have lots of court of appeal justices sitting well into their 70s and 80s, enjoying the job and performing at a very high level. And then you have some of the younger justices like myself with 2 kids in college who are interested in pursuing one more chapter in our career. So I think those are kind of the factors that go into retirement decisions.
Well, let's talk about some of the benefits now that practitioners can reap from young justices like yourself retiring from the bench and making your services available as a neutral to other practitioners. You wrote in the Daily Journal recently that counsel should consider hiring neutrals with appellate experience to help select issues for appeal and even to draft the appellate briefs. And you noted that most appeals are won or lost on the briefs. In your experience as a justice, Justice Thompson, what are some common briefing problems you saw while on the bench?
Well, I'm all about the basics, believe it or not. I think you need to cover the basics before you get to the more advanced subjects. And I was surprised as a Court of Appeal justice at how many people didn't pay attention to the basics. Now, it might be that they don't practice appellate work regularly, and so they're not familiar with the basics. Or it might be that the matter that they're involved with, the economics are such that their clients are not willing to pay whatever time it takes to cover all the basics. But I'm talking about simple things like following the California rules of court, making sure that you don't forfeit an issue for failure to follow the California rules of court, explaining to the court how your client was prejudiced and why they should, what relief you're asking for and why they should get it. Things like selecting the important issues, discarding the weaker arguments which just distract from the really important and central issues. Things like being true to the record. You would be amazed at the number of people who will make factual statements with either citations to the record that aren't supported by the citation or without any citation to the record at all, and it turns out to be a contested or at least a disputed fact. And I guess another thing that I've seen as a basic problem is unwillingness or inability to grapple with really difficult issues. Some people's approach to dealing with difficult issues is to just ignore them and pretend like they're not there. That's rarely helpful because we're going to get into it. It's much better to grapple with it and explain why, yes, it appears to be an adverse case for my client's position, but my client deserves to win anyway.
Yeah. Can Can counsel gain credibility with the research staff or the justices by conceding bad fact A or conceding bad issue B?
Absolutely.
Yeah. Okay.
Absolutely. And the better lawyers do that all the time and gain a lot of credibility with the court in doing that. They then, of course, go on to explain why their client should win, notwithstanding that bad fact or bad case that's out there.
I know the court is buried with, criminal cases and lemon law cases. And so you see, it's just the volume of cases you have to deal with is tremendous. But even with that volume of cases, do the research attorneys and justices tend to remember certain lawyers as, hey, that guy, he really, knows how to brief a case and he concedes the issues and he's presenting well. And, oh, this lawyer, he never supports his briefs with facts, etc. Do attorneys gain reputations with the with the appellate staff?
Yes.
Yeah. Interesting. Well, let me ask you this. After a trial is done and there's a winner and a loser and emotions are high, sometimes people are super entrenched in their position. The loser felt they should have won. The winner is giddy. What are some signs that a case like that might be a good candidate for mediation before appellate briefs are filed and an appellate lawyer is retained?
Ooh.
What makes for a good post-trial mediation?
That's an excellent question, and the first thing that comes to mind is allowing a little bit of time for people to recover from the outcome of the trial. And maybe that time is consumed with post-trial motions and preparation of the record or whatever. But I think it's incumbent on the lawyers to try to maintain some objectivity and think realistically about what's best for their client. The appeal that's almost always a slam dunk loser is the one that basically re-argues the trial that they lost. You see that more often than you would like, and it's just not an appeal that should have ever been filed, or at least it shouldn't have been prosecuted in that fashion. But oftentimes you have parties that are seemingly far apart in terms of their evaluation of the case. And as a neutral, I'm coming to realize that I can pretty much ignore the opening offer and the opening demand. And what looks like an insurmountable gap, actually at the end of the day, turns out to be something that can be bridged, and we can find a resolution that makes sense for all the parties. And a lot of times the clients just need to hear directly from a judge who's tried a bunch of cases or heard a bunch of appeals. These are the facts of life, and I'm not talking about any rocket science here. I'm just talking about how long an appeal takes, what the likelihood of success on appeal looks like, what success looks like on appeal, and so on. I think when clients can hear that stuff in the cold light of day from a judge or former judge, it can be very impactful for them.
Are there some clues that you can spot or the counsel can spot when that might be the case for their particular situation, if they know that the other side is just light years away from them in terms of settlement position? Are there any clues that, I think they're really just wrong-headed on this one legal issue, and if I could get a retired Court of Appeal justice to explain the realities that, you might not be right on that could turn everything around? Are there other kinds of clues that might be a successful way to go?
Nothing else comes to mind, but I agree with what you just said, that might be, having a so-called evaluative mediator as opposed to facilitative might be super helpful in that case. I sat right here in this conference room recently and looked at a client who was complaining that he'd spent $5 million in 5 years litigating a case, and to no avail, and his appeal is now pending. And I basically told him, I think you're looking at another 5 years and another $5 million, and you're likely not going to be in any better position 5 years from now than you are today. And I think
Wow.
you ought to really seriously consider settling this case.
On the topic of settlements, are there any situations where you would suggest that lawyers should consider a post-appeal settlement? So the appeal is done, or at least the briefs are done and the argument's done. What are the unique dynamics behind post-appeal settlements, including the fact that the Court of Appeal might just decide to decide the case, even though the case settles?
Yeah.
Right. I don't have a lot of experience with this. In my 10 years on the court, it didn't happen very often that a case that was fully briefed and ready for argument settled. And it happened even less frequently that the parties did settle under that scenario, and they wanted the appeal to be dismissed, and the court refused to dismiss. I can count on one hand the number of cases I was involved with where that happened. And it was always, just like the rule says, an important question, perhaps a question that had statewide importance to a large number of litigants. And more importantly, it was a question that might otherwise escape review by the Court of Appeal for whatever reason procedurally.
And let's move on to talk about, you had alluded to brief writing from your time on the bench. You shared some of your tips about best practices in brief writing, and one of the tips that you shared, I believe it was in a daily journal article that you published, is about the importance of using signposts in briefing. And I take this to mean when you talk about signposts, that means well-developed headings. How do justices use headings in appellate briefs and in the table of contents? Is there such a thing as using too many headings? I always err on the side of more headings, the better.
Objection, Your Honor. The question is compound.
Yeah, I told you could raise a lot of compound objections to my question.
Sustained.
Look, we often look to the table of contents and the outline of the arguments to understand what this case is about. That may be your very first impression of a case. So it's super important that you have a logical and easily understandable good first impression table of contents. And likewise, the headings. You probably know there's a specific rule of court that when you get to your arguments.
Justice Thompson, sorry, I hit the wrong button there, so I'll let you resume. You're talking about the California rules of court, rules about the use of headings in appellate briefs.
Right, and there is a rule that requires you to have for each discrete argument a separate heading. And if you lump 3 or 4 different arguments under a heading, the Court of Appeal might just overlook something. And so it's important, you can end up forfeiting or not having an issue be properly addressed by lumping things together. But it does give the court a roadmap for deciding the case. I'm a big believer in the use of headings to structure the arguments. It makes things so much more understandable. It's like point, discussion, and the things flow more logically, and it sticks in my mind better. When I talk about signposts, though, I'm also talking about, in addition to headings, things like transitions between paragraphs and between arguments. When you start a whole new section of a brief, say, in this section, we're going to address this issue, and it breaks down into these 3 parts, and then you go down those 3 parts under each separate heading. It just helps to keep the stuff organized in your mind. You got to remember how many briefs your audience are reading, and anything that you can do to make it more easy to digest in the first instance, or just as important to remember later on, is to your benefit.
I was in a discussion online with some other lawyers who talk about nerdy lawyer things like this, and we talked about the signpost moreover. And in my position on moreover, or in the position of some other lawyers, is that moreover is kind of a cheap signpost, because it really is just another word of another way of saying I'm going to keep talking now. It doesn't really indicate that you're talking about a new argument or just an elaboration of the same argument. What do you think on moreover? Is that a sufficient signpost?
It's a weak signpost. It's overused. If I was going through a draft opinion and editing, and I came to the second moreover, I would probably go to my thesaurus and see if I can find another word. If you look at Justice Bedsworth opinions, by the way, you won't see that word ever appear. And that's because he's very, very careful about finishing an idea and starting a new idea and telling you, hey, I'm starting a new idea here. It's disciplined writing, but it touches on a thing about published versus unpublished opinions. Most opinions are going to go down as unpublished opinions. Most unpublished opinions, a nice, well-equipped Chevrolet is okay. For a published opinion, I'm looking for a really nice, high-performance Porsche or Ferrari. But to turn a Chevrolet into a Porsche or Ferrari takes a lot of time and energy. And so query whether it's worth doing that in the average unpublished decision.
Is there any difference, speaking of the difference between published and unpublished, is it, you talked about the quality of the brief, or the quality of the opinion is a factor. What about just the nature of the reasoning? Are published opinions, do they tend to be narrower, or do they tend to be a little bit broader because they're going to be published, they're going to be applied in more circumstances than just the facts at hand? Is that a consideration in preparing published opinions?
I don't think narrower or broader is necessarily the issue. But I take philosophically the point, if I'm going to publish a decision that's going to become part of the jurisprudence of the state of California, personally, I'm going to try to make that decision as narrow as possible, because I'm not smart enough to figure out the number of permutations under which it could be applied that I can't even begin to contemplate, which might lead to a result that wouldn't be warranted. But really, some people publish a lot of decisions. I published very few decisions that I was the author of. I just didn't think there was anything truly publishable in most of those opinions, and filling up the books just to have an opinion on every issue from the 4th District Division 3 when there's a perfectly good decision directly on point from the 2nd District, that doesn't make any sense to me.
Is there any difference of opinion that you've detected among your colleagues toward publication of opinions? Are other of your colleagues more interested in publishing more opinions, or?
Absolutely. Yeah, I would say most of my colleagues were some very interested in publishing a lot more than I was. I probably published the fewest number of cases. I wrote the most dissents, but I published the fewest number of cases.
And is there a judicial philosophy behind that?
I think it's just the standards for publication should be strictly adhered to. It really should be a case where you're either announcing a new rule of law, or you're clarifying an existing rule of law, or you're applying an existing rule of law in a novel set of circumstances. But it partly goes to the difference in function between the Court of Appeal and the state Supreme Court. Well, I had a lengthy discussion with a California Supreme Court justice on this point, and it was explained to me that the role of the Court of Appeal is an error-correcting court. The Supreme Court is a different job altogether. And so if I'm just correcting an error, it's a rare case that's going to result in some important, new or different rule of law that's worthy of publication.
Let's talk briefly about writ petitions. A common question among appellate attorneys is what type of criteria the appellate courts use when deciding to grant writ relief. Do you have any practice tips for appellate attorneys about writ practice, and what is something that's really going to grab the writ panel's attention?
I do. it turns out for a variety of reasons, I spent more time in the writ panel in the last 10 years than anybody else. It's generally rotated on the 4th District Division 3 between the justices every quarter or so, but I ended up serving long tours of duty on the writ panel and saw thousands of writ petitions. So philosophically, I view writs sort of through the lens of temporary restraining orders. And by that, I mean, you really need to demonstrate to me that there's an immediate threat of irreparable injury. There's something that's about to happen that can be prevented, that can't be corrected at some later point in time. You need to remember also that writ relief is an extraordinary equitable remedy. It's only available if the remedy at law is inadequate. Generally, the remedy at law is going to be an appeal following a judgment in the trial court. And the fact that you have to go through a trial is not going to be the kind of injury that's going to get you writ relief. Part of that is practical because 9 times out of 10, if that case goes to trial, it's either going to get settled or we're not going to see an appeal post-trial anyway. So the issue is going to go away. But the point is, you really need to demonstrate to me, this is my personal philosophy, why the Court of Appeal should take the extraordinary step of intervening in the proceedings at this stage of the proceedings. And it's a rare case. You know it when you see it within the first paragraph of a writ petition. Oh, wait a minute. This is a case we really need to take a close look at.
In the first paragraph, really? Is that...
Absolutely. If you can't convince me in the first paragraph that somebody's going to die before 5 o'clock tomorrow afternoon, your writ's probably going to be denied.
Well, that would make for a very brief appellate consultation then.
Indeed. Well, you know what the statistics are, and many petitions are denied on procedural grounds alone, and they should be, in my opinion. This is back to being familiar with the rules of court and people that are not appellate specialists doing appellate work. If you don't comply with the rules of court and your writ has procedural deficiencies, it could be denied on that ground alone. And of course, the Court of Appeal is not going to tell you why it was denied.
To what extent does the presiding justice have influence over the outcome of writ petitions, such as by the prerogative to choose the writ panels? If there are there some justices who are more prone to granting writ relief than others?
I think the answer is the PJ has no real influence on the process. The composition of the writ panel from time to time is just, it's a rotating obligation that everybody serves on. But it is true that some justices are more inclined to grant writ relief than I might be. For example, I might have a writ that comes across and I say, we don't need to get involved in this case at this time, or there are procedural irregularities and this petition should be denied for either of those grounds. And one of my colleagues might say, yeah, but it's an interesting issue and I'd like to write on
it. There's no California rule of court that has the interesting issue. I'd like to write about it, grounds for relief. Okay.
I haven't seen that in the rules, but it's to some extent, it's a philosophical question. At the end of the day, what's happening with a writ is somebody is cutting to the front of the line and trying to get the court's time and attention over somebody who's been standing in line and waiting for a year or more to have their case heard.
Interesting.
Yeah.
Hey, let's switch gears to oral argument. A lot of the courts I appear in front of, including the 4-3, start oral argument with an admonishment. Counsel, we've read your briefs. We're familiar with your briefs. No need to rehash those arguments. On the other hand, we're not allowed to argue anything new that's not in our briefs. Given those two narrow confines for oral argument, can you offer any suggestions for our listeners about making oral argument effective?
I'll try. This is a perennial question. You know, as you point out, it's a no-win proposition. Counsel, do you have anything to say that isn't in your briefs? Yes. Why wasn't it in your briefs? You're not going to be permitted to argue something that's not in your brief. On the other hand, If it's in the briefs, why are you just repeating yourself? So the really good oral arguments that I've seen will focus really on the heart of the matter, just the crux of the matter and the key issues. And they'll often find a slightly different spin or theme to put on the. Last week, I watched oral argument in a case that I'm working on here. And the lawyer started by saying, as I was reviewing the briefs, I was struck by X, and then he launched into a slightly different take than what was articulated in the briefs. Nothing new, but just a little different spin. And I thought that was really well done. The real reason in the majority of the cases for oral argument, in my opinion, and maybe this is going to touch on the question of tentative opinions and that were suggested we might talk about today, but the real reason to be there is to answer questions from the panel. Make a few key points, but most important, be prepared to answer questions if the panel has them. It also gives you an opportunity to comment on the reply brief. So there's an opportunity where you wouldn't have a chance to say something in writing. And maybe it's an opportunity to concede, as we were discussing earlier, to concede a point, but explain why your client still wins, despite that concession.
Yeah, interesting.
Well, since you did mention tentative decisions and focus letters, most appellate attorneys that Jeff and I talked to would love it if there were more courts issuing tentative opinions and focus letters. Do you have any insight on that topic? Of course, the 4-3 doesn't do those. Was there a reason for that? Do you forecast that at any point in the future the 4-3 might start issuing focus letters or more focus letters or tentative opinions?
Well, let me start out by saying that I'm a big fan of, if not full tentative opinions, some of the other courts experimented with, but at least focus letters. And it comes from my experience as a trial judge, hearing thousands of law and motion matters. I issued a tentative ruling in every one, and the result was that I was having a discussion with the lawyers about the points that I thought were important, regardless of whether they thought they were important. A surprising number of oral arguments, the lawyers standing up and arguing issues A, B, and C, when I'm sitting here really being curious about issues D, E, and F. And so there's a complete disconnect. We're like two ships. So the quality and the value of oral argument would be enhanced if we use a focus letter or even a tentative opinion. The resistance to it is, I think, largely custom and practice, and maybe somewhat generational. But there is a valid point of view which says we ought not to even indicate a tentative view of the case prior to oral argument, because we want to have a truly open-minded oral argument. But the fact of the matter is most cases are decided on the written briefs. And so it's a reality that oral argument is of marginal utility in the average case. That's not to say that it doesn't ever happen, that an outcome changes at oral argument, or an issue, the way an issue gets treated changes at oral argument, or we don't get through halfway through oral argument and suddenly the light comes on and we say to ourselves, wow, this is one we really need to go back and take another look at, because I completely misapprehended what this case was about. That happens, but it's a small number of cases. And so to the extent that oral argument is beneficial, useful to the court, I think the quality would be improved. But I think there's going to be resistance until you get younger justices that are maybe interested in doing things differently. It would require the court to change the way it does business as well. We would have to have something that looks a lot more like a finished product before oral argument, because we wouldn't want to distribute those drafts that we use for summaries prior to oral argument. So you would have to accelerate the internal processing of the case and advance the time that you have a more finished product, have that happen before oral argument.
Interesting. Hey, let me ask you this on the issue of oral argument. Justice Bedsworth wrote in a recent column that oral argument requires a lot of extra preparation time in terms of the panel. And that it would be nice if more parties submitted on the briefs and simply waived oral argument. Is that a common sentiment on the appellate bench, that the justices wish more arguments were waived?
Well, I'm not sure. I think it is common. A common sentiment is we didn't get much out of oral argument on this case or that case or the other case. Back to your point earlier about the differences between criminal and civil cases, many more criminal cases get submitted on the briefs and oral argument is waived. That usually is because the issue is very well defined and the court just has to make a decision. There's not a dispute about the facts or the law. Civil cases, not so much. But regardless of whether there might be a preference for less oral argument, I would never, in a civil case, if I were a practitioner, I would never waive oral argument. I would always show up and make some brief remark and at a minimum stand up to say that I'm prepared to submit on the briefs unless the court has questions, because this is your only opportunity to gain some window into what the justices are thinking and to, at the margin, assist your client and increase the likelihood of success. You never know which case it's going to be that the court has a lot of questions in. So yeah. With all not due, but more than due respect to my good friend, Justice Bedsworth, I still would advise civil practitioners to show up. Keep it brief. Make one point. Offer to submit on the briefs unless there's questions, but don't waive oral argument. I think it sends a message that you don't feel that, or your client doesn't feel that it's important enough to show up for oral argument.
That's an interesting perspective. And that's useful because I did want to ask you one other question about oral argument, that counsel after oral argument are always going to try to read the tea leaves, right? Because they have anywhere between the opinion could be issued later that afternoon, or it could be 90 days from then. And until then, your client wants to know, how did it go? What are the justices going to do? And so you're stuck trying to read tea leaves. Well, they asked the other guy a lot of pointed questions, so that's good for us. Or the justices asked me a lot of questions, so that's bad for us. Are these useful ways to get hints about where the court is leaning, or are they just divining rods?
I think it's very hard to predict the outcome of a case based upon the questions. Unless you know the personalities very, very well, I think it would be hard to really read too much. Questions get asked for a lot of different reasons. Sometimes they're asked because the court really wants an answer. Sometimes it's a tough question that the court is really grappling with and it wants additional input from the lawyers on that question. Sometimes it's a softball question and the justice who's asking the question wants the lawyer to hit it out of the park because somebody else on the panel is having heartburn about that issue. Sometimes questions are asked of the party that's going to lose. Let me back up. Sometimes questions are asked of the party that's likely to prevail so that the party who's going to lose feels like they got a fair and full hearing. Sometimes questions are asked, I speak for myself, in order to keep me mentally engaged and make sure that I don't start dreaming about fishing in Mexico in the middle of some oral argument.
Interesting.
I'm being a little bit facetious, but the point is there's a lot of reasons why questions get asked. The idea that questions are asked to help resolve a division within the panel, that's a rare case in my experience, and beyond that, it's just very hard to know. Back to your hard-headed comment that Bedsworth said about me, I usually ask questions to tell you exactly where I'm going, but I think I'm the exception, not the rule.
So Tim, when the podcast gets our first law clerk, we'll need to have that law clerk do a statistical analysis of the number of questions asked to the prevailing party and whether there's a relation between winning and getting a lot of questions at an argument.
Yeah,
that's a great idea.
Yeah, I think that analysis has been done. We'll share it in a later episode. But I remember reading that, and
all right.
But the statistics can be used to prove anything. 56% of all people know that.
But
All right.
there's wide differences between courts and the culture of the courts, the so-called hot bench versus the not hot bench. Some courts are just not in the habit of asking very many questions. Some are in the habit of asking a lot of questions. Some of the justices just love to have a give and take with the lawyers because they miss being in a trial courtroom where they can have real interaction with litigants and lawyers.
Yeah.
Hard to know.
Yeah. Well, to close, Justice Thompson, I wonder if you could just share any other examples or lessons from your career about what it takes to make an advocate stand out. Now, you've written, we talked about some of your writings in the Daily Journal and elsewhere about how important it is to know the rules, as you talked about today, and to be civil and courteous with opposing counsel, how important it is to be honest with your own arguments and to concede issues issues and facts that you're just not going to win on. Are there any other maybe rare experiences that you've had with really outstanding counsel that you wish would become more typical in our profession?
Well, the prepared advocate is always going to stand out. And you talk to folks that do this work on a regular basis. They spend ungodly amounts of time and energy preparing. And so the prepared advocate always stands out. So preparation are my first three answers to this question. But I'm thinking back as a trial judge, because I know some of your lawyers are also going to be trial counsel. The really outstanding advocate looks and sounds like this. There's a witness on the witness stand. The lawyer has a prepared set of questions that they're trying to cover with that witness, but they're listening very carefully to what the witness is saying. They're watching the judge's demeanor. They're watching the jurors to the best of their ability. They're probably watching the bailiff as well. And they're constantly adjusting their game plan in real time as this entire little drama is taking place. And they're making it all look like they're having a fireside chat with somebody. Like they're very relaxed, they're very comfortable, but they're working off a script, but adjusting the script, and they're most importantly asking the follow-up questions, the clarifying questions of the witnesses, knowing exactly when to ask another question or whether to leave that answer for argument. It's like poetry in motion. And when you see an advocate, look, I don't think trial work is rocket science. I think any reasonably competent lawyer, if they have enough practice, can get to it. But the one I'm talking about now, this is the Tiger Woods lawyer who was born with this skill. It's unbelievable to watch these people work. It's just beautiful. So I don't know if that answers your question, but that's something that has always stuck out in my mind. There's a handful of those guys that I met in my career, and having them in my courtroom was always a pleasure. Absolutely.
Yeah, no, that was a great answer. So, 6 sets of eyes and 3 sets of brains. You need an attorney with those attributes to see what's going on and to reflect back and reflect questions and have a real understanding that the lawyer was listening and using what he listened to bat it out of the ballpark.
And no matter what the witness said, especially if it's an answer that is surprising and perhaps even damaging to your client, you act as if you fully expected that, and you smile and you move on to your next point, and you just make it all look relaxed and easy.
That's right.
Well, Your Honor, we want to thank you for spending this amount of time with us. You've been more than generous, and I learned a lot. We also want to thank our sponsor, Casetext, for sponsoring the podcast. Each week, we include links to the cases we discuss using Casetext, and listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
And if you're listening to the episode and you have suggestions for future episodes and guests that we might invite on, please email us at info@calpodcast.com. And in our upcoming episodes, look for more tips on how to lay the groundwork for an appeal when preparing for trial.
See you next time.
Thank you again, Justice Thompson, for joining us.
My pleasure. Thanks for having me.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.